Hello, everyone, and welcome to Interactive Legal's speaker series. And today's topic, 31 flavors of SLATs. My name is Teresa Bush. I'm the Director of Education for Interactive Legal, and I am honored to get to co-present today with Jonathan Blockmacher and Martin Shenkman. The title of this webinar actually came from a comment that Marty made when we were in the Heckerling Review webinar, and he said that there were many varieties of SLATs, far more than 31 flavors, and we will be talking about the number of options and how the number of flavors is actually exponentially higher. Before we jump in, I want to cover a couple of housekeeping webinar information items. There are 2 handouts which you can download by clicking on the handouts icon, or you will have received a link or 2 links to download them in your reminder email earlier today. The same links will come in a follow-up email later today. If you have trouble at all downloading the handouts, please email events@interactivelegal.com for assistance, and we can help you with that. The presentation is being recorded for later viewing, and you will get a link so that you can watch it in those same follow-up emails later today. You can ask questions, and we'll monitor them throughout, and so we might be able to jump in and take some of the questions live. Do that by clicking on the chat icon at any time during the presentation. You also might post a question, and you might get a written reply from me if it's something that, Jonathan or Marty answer the question as we're going along. So that'll be in the chat area too. So we are fortunate to have with us today 2 attorneys whose names you are probably very familiar with. Both are prolific speakers and authors, and you've likely seen them in our prior webinars. Jonathan Blockmacher is the founder and editor-in-chief of Interactive Legal and a retired partner at Milbank Tweed in New York. Martin Shenkman is a practicing attorney in New York at Shenkman Tietz, and he is an Interactive Legal advisor. Thank you both for joining me today so we can talk about SLATs, and I will let you take it from here. Marty, you have the reins.
Well, Marty, let me just make one comment. The name SLAT, which is, a lifetime or
Spousal Lifetime Access Trust.
Yes, doesn't it? It's a Spousal Lifetime Access Trust. Now, the first time I saw the acronym SLAT, there was an article in Steve Leinberg's materials, and someone wrote an article which he called a Spousal Limited Access Trust. And the author contended that you might want to do this for your spouse, but you've got to really restrict what your spouse can get. He was under the impression that if you allowed distributions for any broad reason, particularly if it was for the spouse's health, education, maintenance, and support, that you would have a state tax inclusion for yourself because the trustee could use it to benefit your spouse, which might benefit you. Now, Mitchell Gans and I wrote a follow-up article in which we pointed out that no, you don't need to limit access. So it's not a spousal limited access trust, it's a spousal lifetime access trust, which generally you can make as broad as you want. Just wanted to give that background on the meaning of SLAT. Marty, go ahead.
So let me just comment on why we're doing the program and what we hope to accomplish. And it may be that every technique and variation of SLATs and every mechanism that you may or may not include in a SLAT or SLAT-like trust, everybody on the program is familiar with, or maybe. But the purpose, our goal, was to talk about and emphasize the incredible variations and differences one can create under the broad moniker SLAT, or I kind of try to use SLAT-like trust because there's so many variations of even that, like a SPAT and hybrid DAPT, and we'll talk about that. And the reason that I felt it was important to do a program like this is, and there's no disrespect and no disagreement intended, but Heckerling this year had a number of programs that talked about divorce risks and joint representation and SLATs. And I remember sitting through Bruce Stone's discussion thinking, would anyone do all these wrong things that he said? And within a week of getting back, I got hired on a matter where, yes, somebody did even actually worse than the things that they were using as hypotheticals. So it all does happen. But I wanted to put a different spin on the discussion because I think it's helpful for practitioners and clients. And that is, we should be very careful making broad generalizations about any technique we use, SLATs, apropos to this discussion today, because there can be so many different ways that you can apply a particular technique. So, you know, the old style irrevocable life insurance trust, the old style ILET that we did for years, I would say that the vast majority, Jonathan may disagree, but certainly the vast majority that I saw over, and I still see because they're still out there, was you know, husband would be named a trustee of the trust wife created, wife would be created, named trustee of the trust that husband created, home state trust, no tax reimbursement, no complex provisions, no trust protector, no change in situs. But those were SLATs because the spouse was a beneficiary. Husband bought life insurance on his life in a trust that benefited wife. So those are perhaps, and still could be, the simplest version with the least number of options of any SLAT you may ever do. And just a quick comment with drafting software, and I know this is for ILS, so we're going to talk about ILS, but if you use a different drafting software, shame on you, but that's a different discussion. But you can do this in any drafting software. So I don't mean to just promote ILS because it's the concept of document generation. You can do a simple ILET in document generation, but literally for a couple of minutes more of time, you can make it so much more robust of a trust than just this standard simplistic ILETs of the days of old. On the far other end of the extreme, you could do a really sophisticated SLAT that's intended to do like a $1 billion note sale transaction and everything in between. So if we talk about SLAT as a concept, it's so broad and there's so many variations on how you apply it that I think we lose something very important in that generalization. And the goal for today is to try to reemphasize and remind all of us of how much ability we can have to tailor a SLAT-like trust to every unique client circumstance. And that is really powerful. And I realized when we were creating the slides and talking about this in planning the program, that it really, and it wasn't my intent to advertise document generation in ILS, but it kind of led into that because if you use drafting software like ILS to the full, broad, flexible extent it permits, you can make so many different decisions. So there was, you know, some people feel that, you know, you need to have a certain amount of wealth before you can really create a SLAT. I don't know that that's really true. So if I have a young physician come to me, especially a surgeon, because if the stats, if I remember them correctly, something like 20% of surgeons get sued every year. So the malpractice exposure is really substantial. Why not get the SLAT started today, even if they don't have a lot of wealth, because now you've created the trust and time passes. The recent Delaware DAPT case, and Jonathan, if you know the right name, I probably may not say it right, but something, it's a weird name, something like CES Trust 2007.
Correct.
And the court really stressed the fact that that trust was created 7 years before the business endeavor that gave rise to the claim. So if you have clients come to you that are young, why wouldn't you create a SLAT at a young age? You now have the benefit of hopefully a lot of time before a claim should occur to enhance the asset protection. And
make sure, by the way, make sure you create that SLAT in a jurisdiction which provides a lot of asset protection, not just for the beneficiary, but for the grantor as well.
So I'm gonna plug, we're gonna do a follow-up session where we're gonna talk and demonstrate how to draft and how you can use AI, which is unrelated to ILS, but how we use AI in how we draft in a very different way than I think most people do, that you may find interesting. But we're going to demonstrate the drafting techniques, the decision process that goes into it. And while Jonathan just made a great point, I prefer, and the default answer I have is, if I do SLATs for clients, I'd like one in one DAP jurisdiction and the other with an independent different trustee in a different DAP jurisdiction. I like institutional trustees, different DAP jurisdictions. However, when you have a young couple that comes to you, cost is going to be a big factor. You may be able to simply keep it as a home state trust with Uncle Joe on one trust and Jane on the other. I don't like using the spouses, although I acknowledge most of the old ILATs were done that way. I think it's just safer to have somebody that's not the that close to the plan, and give a trust protector the right to remove and replace trustees and change situs and governing law. And as soon as it's appropriate, reasonable, cost effective for the client, move it to the better jurisdiction, as Jonathan said. But what we just talked about, of maybe the default answer, as Jonathan brought up, being an adapt or better jurisdiction for asset protection versus starting in a home state because the client's wealth is so low, but they want to get the time clock ticking. That's just illustrative of so many different variations of how you can handle it. And that's why I think it's important not to get focused on a particular acronym or a particular format for a SLAT or any other technique, but rather how can we use this technique for each specific client that's in front of us.
Well, and I think we've already started to cover this, which is, what is a SLAT? And so we'll skip past that pretty quickly, even though it is in the handout on the next slide. It's an irrevocable trust where the spouse is a beneficiary. We often get asked, where is the SLAT form? And the SLAT form is any irrevocable trust that has the spouse as a beneficiary. So when you were talking about the acronym, I tend to hate acronyms unless they happen to be one that's in the Internal Revenue Code and we've adapted it from there. But ones that we just create ourselves, we can come up with all kinds of crazy acronyms for trusts. I do think that people like to have a checklist of all the issues I need to think about. And that's often where any drafting software, like you were saying, Marty, I think is helpful because it brings up the issues where you have to decide upon them. So you have to think about them. And you might have not remembered that issue if you didn't have that type of checklist. But having a checklist of all the issues, in some form or fashion, is going to be helpful. And that follow-up webinar that Marty was mentioning, we're going to have it in March. So stay tuned for that.
Let me make a couple of comments because you made a really great point, Teresa. You can't get hyper-focused on an acronym, and clients do that all the time. And now with AI, I'm finding a lot of the inquiries we get are not, can you help me with an estate plan? It's, can you do, and they name whatever acronym AI told them they need. I mean, I had a call a few weeks ago, somebody wanted to beat it in Nevada. Somebody else wanted a backdoor SLAT in Georgia. Where do they get this stuff? But let me change your perspective on this. It's not about, I'm doing an ILAT, I'm doing a SLAT, I'm doing a DAPT, I'm doing a whatever, a GRAT. I think the better perspective is, and we all used it as kids, Lego, right? Building blocks. What components do you want to assemble from the big toolkit you have to create the trust and the plan and the document that works for that client? And if you use the Lego approach, I think you can have a much more flexible, tailored result. And the beauty, and I don't get a commission, so forgive me, but the beauty of ILS, what it does, as you click through the different screens, I don't know if there's a different word you use for it, it is a checklist because it's saying, hey, do you want to use a definition of spouse like this, that, or the other? And may give you 3 options. That's a checklist that makes you think through the plan. Many people draft by having a pre-structured document that may be their own form, or they may go through ILS and select and create their own template. We used to do that. And I found for the little bit of extra time, I kind of like going through the full, what's the word you use in ILS when you don't have any pre-selected choices?
Oh, we call it no preset answers. So you're starting with a blank slate, essentially.
which gives you the most options. And the reason I like it, even if I know exactly where I want to go on a particular matter, and I'm sure most practitioners that have been doing this for a long time, you know what kind of trust you want, you know what you want in it. But I find it really helpful to ponder the queries that come up on the screen when I don't have pre-selected answers. My tendency is to go to the pre-selected answer that I kind of thought ahead of time I wanted, but it's helpful to look at all the other options. And that's kind of what we're trying to illustrate in this program, that there's so many different options. So it all depends. Whatever you choose to do, it depends. It's a very flexible tool, the SLAT or SLAT-like trust, and there's lots of different things that we can build in. So, Jonathan, you want to talk about some of the concerns that people have in SLATs?
Well, one of the concerns is how are you going to define the spouse, which you indicated before? Because you may be very happily married, or you may think that if you do this trust for your spouse, it'll make the marriage happier or last longer. But in fact, we know that, you know, close to a majority of marriages in the United States terminate by divorce and not by death. And you also got to consider that even if your marriage does end by the death of one of the spouses, what do you want to have happen to that property then? Do you want it to be available for your new spouse? Or if you get divorced, do you want your new spouse in there? That's one of the most important questions you can ask. So you just don't put in, you know, Teresa does a trust for her husband, and, you know, but, you know, Teresa's husband passed away, unfortunately. So Teresa, being young and beautiful, no doubt will remarry. And the question is, does she want that new husband to come in? So one of the choices that you have is to define the spouse as either the person to whom that person is married at this time, or the person to whom they're married at a later time. Because it may be important to keep your spouse in as a beneficiary, which is going to give you more access to the property. But there are consequences to that. If you create a trust for your spouse, unless you do it in a very peculiar way, that's going to be a so-called grantor trust, which means that the income of that trust is going to be attributed to the grantor, even though the grantor is not a beneficiary. And that's a very hard thing to accept. Wait a minute, I created this trust for my spouse. Why am I being taxed on the income? Well, you can ask your Congress people why that's the rule, but it's the rule in the Internal Revenue Code. So if you take a look at section 677, you will see that if you create a trust for the benefit of your spouse, you, the grantor, are going to be the income tax owner of that trust and its assets. So that's one of the #1 things that you have to consider, is how do we want it defined? Now, by the way, if you go into a couple and you say, well, Mary Ellen, I'm going to go ahead and I'm going to define, your husband's spouse as the woman to whom he's married at the time in question. Don't be surprised if she bites your head off. What do you mean? Well, there are two problems. #1, there's a suggestion that they might get divorced. And you can say, no, this is really just in case of death. But then the spouse may say, well, you need to draft it that way. But that can be a hard thing. And keep in mind, you may be representing both the husband and the wife, or two wives or two husbands or whatever. And you've got to think through what they want and what it means. I mean, and you can't even be totally sure. If you have a heterosexual marriage now, that could become a single gender spouse at a later time. And I've seen that happen, including in my own family. So don't be so sure. You need the flexibility, but keep in mind, you don't want to offend people. And you've got to phrase it in such a way that it's for the benefit of both of them. But then again, if you're doing one, if I do one for my wife and she's not doing one for me, and I say, well, I want this trust to define my spouse as the woman to whom I'm married at the time in question, my wife may be very upset about that. Now, if you've done one for the husband and one for the wife, and you have, spouses in there as the beneficiaries of both of them, maybe you won't have that same kind of negative reaction, but it can be very negative, and I've gone through that. So you've got to be very general in bringing that up. But don't be surprised if someone gets very upset by how you define spouse. Now, if we say, well, wait a minute, the husband creating one for the wife's creating one for the husband, we can define the spouse any way we want. Well, maybe you can and maybe you can't, but keep in mind that you may wind up having people upset, but even more likely, it may be that the practitioner says, well, you really shouldn't have Marty create a trust for Patty and Patty create a trust for Marty because of the very scary reciprocal trust doctrine, where the trust that Marty has created for Patty is treated as though he's created it for himself because Patty has created a trust for him. That comes in part from a very famous case called the State of Grace. And by the way, for those of you who are of the Catholic persuasion, that's a state of grace, not state of grace, okay? But you need to really think that through. But you've got to worry about that, and we'll talk about some options that you can put in to try to reduce the risk of that. We don't know how different, either in time or asset base or trustee or governing law, it has to be to avoid that doctrine. And the IRS hasn't pushed it very much, but you don't want to be the one to have to tell your clients, well, the IRS has come in, Marty, and said, you're really the beneficiary of this trust that you created for Patty because Patty created a trust for you. So you need to be very, very careful of that.
Let me make a couple of comments, but before I do, let me, Jonathan, you earlier said, and I agreed, subject to one caveat for a younger couple or a couple with lower assets, to put the SLATs in DAP jurisdictions. If I put a SLAT in Alaska and my wife creates a SLAT for me and we make them non-reciprocal and hers is in Nevada, both DAP jurisdictions.
Well, Marty, let me, you said we'll make them non-reciprocal. What do you mean by that?
We're going to build in enough differences so that our position is we are in a different economic position after the creation of this plan than before. And that was the test in Grace, as I read it. Well,
but Marty, there are plenty of statements that, you know, even if, say, I create a trust for my wife and she's, you know, definitely entitled to all the income, she creates a trust and I'm not entitled to all the income, I'm only a discretionary beneficiary, I'm not sure that that winds up really being a sufficient difference, especially when they occur at the same time. And the trust lawyer has said, don't worry about it, Marty and Patty. Everything is going to be available to both of you for all time or the survivor of you. So
well, you got to be careful what you say too.
You've got to be very careful. I mean, what Marty has suggested, which is to use different states, different fiduciaries, and different terms, is very, very helpful. But you can't be 100% sure, although we're going to talk about something called a SPAT, which I think probably does prevent the reciprocal trust doctrine from applying. And keep in mind that the reciprocal trust doctrine first came about not because of taxes, but because of a New York case decided in 1901, long before the estate tax, long before the income tax, where the court said, well, even though someone else created this trust, there was a quid pro quo. And so we're going to treat the person who was the beneficiary of the trust as though she was the grantor, and therefore we're going to make it accessible to her creditors. One of the things that tells you is if you are worried about that, and I think you should be, maybe you want to make sure you go to a jurisdiction where they will respect self-settled trust. So at least you won't have to worry about the asset protection features, but you will have to worry about the estate tax and possibly income tax features of that trust.
Jonathan, if two trusts are deemed reciprocal, the consequence is to uncross them and treat it as if, let's say, I created the trust for my wife. But if that trust is created in Alaska, where you have self-settled trust language, why, if they uncross it, would it not be a DAPT that might, as a backstop argument?
Yes, Marty, that's absolutely correct. And that's what you want to do. That's one of the reasons you need to make sure if you're doing these, subject to your caveat, Marty, that maybe there's a cost factor which says, you know, the couple really can't afford to go to a DAP jurisdiction. They live in California, they live in New York, which are very bad states for purposes of asset protection and trust. So, you know, but maybe they have a cousin in another state. And there are now, I think, 21 or 22 states, Marty, where we basically have good asset protection trusts in the United States. I mean, there is Ohio. Of course, Ohio may not be the best in the long run because it has an income tax. But, you know, you have at least 7 jurisdictions where you don't have an income tax, and you can go ahead and create them, and you will be able to get self-settled trust legislation through.
Let me make a couple of, oh, go on, Teresa.
I was just going to say, I think we run into the reciprocal trust doctrine a lot because that's kind of, it seems like the best way to plan for this possibility of divorce. Because if each spouse can have a trust, then we've kind of divided things up already, and that makes it, you know, not seem unfair maybe, you know, but so that's why we're always dealing with it. But there's other ways that we can think about what happens in the event of a divorce or death, which is where we lose that access. So I was just trying to bring us back to where we were on the slides.
Yeah, let me make a couple of quick comments on divorce and we'll move on. But this discussion between divorce issues and reciprocal trust issues, there's a point I want to make on that. For several years, the focus of so many discussions on SLATs focused on the reciprocal trust doctrine. And that was appropriate. As Jonathan pointed out, it's a real risk, not just for the IRS and estate inclusion, but for creditors. And then of late, the divorce risk seems to have become the focal point of much of the discussions. I think it's very important that we point out to clients all the different risks and as many of the risks as we can identify, and some of the planning options, and let the client make the decision how they view it. So I may view the potential risk for me to get divorced as 0. That may not be factually correct. Jonathan knows how difficult I am. It may not even be practically correct. But
Marty,
that's for me.
But Marty, you've never been divorced, right?
That's for me.
Oh, you have been divorced. Oh my gosh.
That's
well,
for me.
Even to a wonderful person like you, Marty, could possibly get divorced.
But the point is, it's for us to advise and let the client make the decision. I may weigh the risk of liability creditor issues much higher than the risk of divorce issues. So then it's and every client's going to weigh the different risks they face different, from estate tax to divorce to creditor protection and so on. So we need to inform them and let them make the decision. A couple of quick comments. On the issue of divorce, there is very strong correlation. We're not going to go into it in any detail. I just want to make the point that divorce rates are lower as wealth increases. Financial pressure is one of the number one, if not the number one, cause of divorce. So as wealth increases, the risk of divorce decreases. And I haven't seen data like if it's over 100 million or 500 million, if the numbers start to turn. But once you reach some moderate level of wealth, it's well below what most estate planners will accept as a client, the divorce rate is already lower. The divorce rate is lower as education levels increase. People that are more educated, college or postgraduate, tend to marry at later ages, and their divorce rates are lower. If somebody has a long-term marriage, as opposed to a short marriage that's very recent, the divorce rate for the long-term marriage is lower. If you combine those 3 factors, and it's probably the typical client profile, let's say worth more than $5 to $10 million, married for 20 years, both college educated, your divorce rate is much, much lower than the national average. That doesn't mean anything Jonathan said or anything anyone else has said about being worried about it and addressing it is not important. It remains important. But I think then, you know, you can look at it a little differently. The divorce risk for our clients may be 20% on average. Doesn't mean you don't address it and let the client make a decision, but it doesn't mean the same result if it's a 50% or 45% likelihood. Another point, one of the ways to deal with this is to use the floating spouse clause that Jonathan did. You could split the two slats, a SLAT in half on divorce, and half could be floating, half could be the same spouse. You can use the SPAT and hybrid DAP that we talked about, because now the settler spouse is a beneficiary of each trust. So there's many different options for doing it. And that again, and I want to emphasize that the theme of what we were trying to accomplish today, you can't say SLATs are bad because of divorce. It's really for the clients to weigh that versus the other goals that they are trying to achieve that a SLAT may be perfect for. And if you use a SPAT, a hybrid DAPT, if you use floating spouse or you divide the trust, these may all be different ways to mitigate, not eliminate, those problems and risks. One of the things that I've heard people talk about, and in some cases it makes sense, is you remove the spouse in the event of divorce to cut off the grantor trust problem that Jonathan talked about. The problem there is, unless the couple has so many non-trust assets and so much wealth that they have plenty of other assets to divvy up, if I create a trust for my wife and it says if we get divorced, she's no longer a beneficiary, it just goes to the kids, we've just lost access to all those assets for our financial well-being post-divorce. That could be the worst result. In some cases, it may be the right result. It all depends. And that's the theme of what we're trying to get across. The options should be looked at and tailored to what each client's circumstance is.
Marty mentioned the concept of a SPAT, which is an acronym for Special Power of Appointment Trust, and you can read all about that in the February 2019 issue of Estate Planning Magazine, in an article by Abby O'Connor, Mitchell Gans, and me, where we point out that what you maybe want to do is not create a self-settled trust where you're a beneficiary or can be added to it as a beneficiary, but create a trust just for other family members, but give 3 people whom you trust special lifetime non-fiduciary powers of appointment, which allows any one of them to exercise it in favor of any descendant of the grantor. That will not make it subject to claims of creditors. Take a look at the commentary in section 505 of the Uniform Trust Code, and you will see that just being a discretionary beneficiary pursuant to a non-fiduciary special power of appointment prevents it from being subject to claims of creditors. So that's one of the options you have in building what you want. As Marty points out, you may not want to cut the spouse off entirely or cut yourself off entirely because the family may need that wealth. But if you do a SPAT, you can go ahead and really keep the family in there. And keep in mind, when you get divorced, people tend to act not as rationally as they might otherwise. So you really need to think through the fact that, you know, if they get divorced, there's going to be consternation. People aren't going to cooperate, rather than saying, well, you know, you can go ahead and do these and we'll fix it all out when and if you get divorced. Because when people get divorced, they act very emotionally. And that may mean that your intentions are going to be thwarted. But keep in mind that the concept of having one spouse create a true, you know, SLAT for the other spouse, but having that other spouse create a so-called SPAT, a special power of appointment trust. So you will avoid the reciprocal trust doctrine because creditors can't get it, and the spouse who created the trust doesn't retain an interest in it one way or the other. That spouse is not permitted to be a beneficiary, but some outside people have a special power of appointment which can be exercised in favor of any descendant of the mother of the grantor. Now, the reason I say mother is because you pretty much, you can be sure who is the mother of someone who's born, but sometimes you can't tell who the father is. In fact, I did a lecture a number of years ago for the probate judges of the United States, and one of the things that really shocked them, and maybe it'll shock some of the people on the phone here, is that 20% of children who are born to a married couple are not the child of the husband. Think about that, 20% of the cases. Wow, wow. 1 in 5 children born in a marriage are not the descendants, not the child of the husband in that marriage. That's pretty high. But it does happen. In fact, I'm watching a show on Netflix called Southland, and one of the policeman's wives just told him that she was pregnant not by him. So it does happen. It happens in the real world. And some people might feel, well, that would be pretty good grounds for divorce. Although there are places such as California, whereas if your wife gets pregnant while you're married to her, it is going to be your child for purposes of support and otherwise. But, you know, I'm not sure I want to be supporting someone else's child merely because my wife bore that child and we were married at the time that she got pregnant.
Because you brought up the SPAT, Jonathan, I brought up the screen just to show, you know, the different options. Who holds the power? When does the power exist? You know, and who is the class of people to whom or in favor of whom it could be exercised? So I brought that up on the screen so we could get a feel for that. And then the other screen image we have is about the floating spouse option, which we've talked about, because both of these are options to address the possibility of divorce and the possibility that the spouse who is the beneficiary passes away because we've lost that access. So we had the SPAT provisions, and then we have the floating spouse options here. So it's not just one option that we float in the new spouse. You can pick, you know, how do they want to address this? The floating in the new spouse is the top option, the person to whom the grantor is married at any time. So whether the reason we get a new spouse is because of death or divorce, the new spouse floats in. Or you can say the spouse, you know, who's right now the spouse, continues as the beneficiary, even if there's a divorce. Now, there is a mechanism to terminate grantor trust status in that event, which you can see there's a checkbox there for it. But then you also could say, no, the only way I'm creating this trust is for this husband. And go ahead.
Tell us how that works. I've created a trust for my wife, Betsy. I'm not going to use, you know, she's going to stay as a beneficiary, but the last thing I want, you can imagine if this happened to you, you know, your spouse remains the beneficiary, but you're still going to be given the tax bill.
You mean your ex-spouse?
Pardon?
Your ex-spouse.
Your ex-spouse.
So, you know, that's not going to make you very happy because the rules were changed a few years ago. That it used to be that if you got divorced, it was no longer a grantor trust with respect to you because your former spouse, your divorced spouse now, continues to be a beneficiary of the trust, but that's not been changed. So unless you have an older situation where you're grandfathered, so to speak, from it, you're going to be very unhappy paying the taxes when the money is going to your ex-spouse. So that's something to really consider every single time. We bring in
a consent of an adverse party to any distributions to the spouse.
Right.
Is the way we handle that.
Let me mention something about adverse party. If you take a look at section 672 of the Internal Revenue Code, which I know many of you do, and you certainly will read it tonight with your family at dinner time, you know, it seems like you have a pretty clear definition. It's an adverse party is someone who would be adversely affected by the exercise of the power. But when you take a look at the case law, many of these provisions were basically clarified in litigation in the 1940s and 50s. You will find that it's not so clear. And you might say, well, look, I created this trust for the benefit of my wife and my one child, Mary Ann. And it says that, you know, if we get divorced, then only distributions can be made to my now ex-divorced spouse with the consent of Mary Ann. I mean, she's the presumptive remainder beneficiary. Obviously, she is adverse. But when you take a look at the cases, the courts say, not so fast. We're going to look at the facts. And the facts may indicate that Mary Ann will do whatever the grantor wants because he still has control of most of the wealth of the family. There's no bright line test here, but it's just something to be warned that you can put it in, you know, whatever you want, only with Mary Ann. I think the safest thing you could do if you want to say that I don't want this to be a grantor trust, but you want that former spouse to still be eligible to get distributions, you need to say distributions can only be made not by, with the consent of Mary Ann, but with someone who is an adverse party within the meaning of Section 672. You really need to think about that in your drafting, because I'm going to tell you, you can imagine going to your client and you say, gee, I'm so sorry you're getting divorced. And the client says, I understand I'm going to continue to have to pay the income tax. Well, when we put in this provision, we thought it would prevent it from continuing to be a grantor trust, but I'm sorry, but you're going to have to continue to pay the tax. I mean, that's the kind of thing that I think people could get very exercised about.
Let me make a couple of let me make a couple of general comments first. So what we've just done, Jonathan and Teresa, on the last slide on floating spouse and the last slide before that on SPATs, look at the different variations on the SPAT, how it can be structured, and how the spouse definition can be structured. They're materially different. So that's why I think, yes, we have to worry about divorce risks when we do a SLAT plan. But it doesn't mean a SLAT plan is uniform or treats or addresses that in a uniform way, such that you do or you don't do SLATs if there's a risk of divorce. And even if I'm right, and I believe I am, that the risk for the typical estate planning client may be closer to 20% than the 45% average rate, you don't ignore a 20% risk. But you present the options to the client. Listen, if you get divorced, you, the settlor spouse, are going to pay the income tax when your ex-spouse is getting the money. Are you okay with that? No, I'm not okay. Okay, we can insert an adverse party. That has some risk associated with it, but it's a position to avoid the grantor trust burn when the money's going to an ex-spouse. We could define the spouse as not being a beneficiary after divorce, but that then cuts off the family unit, the two of you, either of you post-divorce, from having access to that money. The other thing we could do is we could divide the trust into two and make half a floating spouse and half the defined current spouse. There's many options. The SPAT technique means that divorce or no divorce, the settlor spouse can benefit from the trust. Let me take that a step further and explain how I would like to think about presenting this to a client. Hey, couple, there's a risk of divorce. If you get divorced, it's going to make financial matters harder. It's much more costly to run two households and two lifestyles independently than one. So your costs are going to go up. We can explain the issues we just talked about. But here's another option. Why don't you think about making one trust a SPAT and the other trust a hybrid DAPT? I believe that the mechanisms are materially different. I would still insert other differences, powers of appointment, 5 and 5, et cetera, but one does a SPAT, one does a hybrid DAPT. This way, the settlor spouse.
Tell us what a hybrid DAPT is. What is a DAPT, by the way?
A DAPT is a domestic asset protection trust. I actually have one. I created it with Peak Trust Company in 1998. So far more years have passed with no issue than the CES 2007 trust. So I hope that means I'm safe. I am a beneficiary of the trust that I created. At the time in 1998 that I created that SPAT in Alaska, nobody was talking about hybrid DAPs or SPATs or other techniques. I may have done that. I probably would, because maybe it's less risk. A hybrid DAP means I'm not a beneficiary today, but I give Teresa, as an independent non-fiduciary, the right to add back either me, or some people like to say descendants of my grandmother, my maternal grandmother, so that it would include me. So I have the ability to get added back. Different than a SPAT, where Teresa might be able, or some other person, I wouldn't want the same person in both trusts, say Jonathan could direct the trustee to distribute some of the trust assets to my wife and her in the trust I create for her and that she created for me. But if you use a SPAT and a hybrid DAPT, it's not just the beneficiary spouse that can benefit, but the settlor spouse can also receive economic benefit from it. If you start with that premise, the clients may say, and I've had clients say this, you know, it's too complicated. I don't want to go to adapt jurisdiction. You know, you've explained that there's not enough, you know, there's not a lot of law confirming that. I'd rather take my chances with just the SLAT because we think we'll be okay financially if that happens. But that's for the client to weigh extra access, more tax risk potentially. You may feel otherwise, Jonathan, versus divorce risk. Those aren't personal decisions we as advisors can make. We can only advise and let the client make that decision. But I think if you present a SPAT, a hybrid DAPT, regular SLATs, all the different spousal definitions that we've just talked about, clients can make an informed decision. And I don't see why that's a risk to the practitioner, because you've offered options that address this risk in multiple different ways, and the client can make a choice if they're comfortable doing it or not. Thoughts, comments?
Teresa?
No, I just wanted to add that we were starting to count the flavors because there are so many options. And I do have one more question that came from the audience that I wanted to ask about the floating spouse, and then maybe we put that to bed and move on. We don't have really an option for this, but let's say I'm young and I'm not married, but you know, someday I'm going to get married, but I have a whole bunch of wealth. Could I put my wealth into a trust, an irrevocable trust for, you know, asset protection reasons or whatever, and have a floating spouse in there for my future spouse? I don't have one today, but if I ever am married, then my spouse is a beneficiary of this trust. What do you think about that idea?
We've done it many times. There's no reason you can't. The one thing you have to be mindful of is you got to have a real current beneficiary. So what we've done where somebody is young, has a lot of wealth, wants to do planning, we might do a hybrid DAPT, because what if they need the money? And you never know over, you know, 80 years that, you know, if they're really young, it could be another 80 years, 70 years. The tax burn, the varied appreciation of different assets in the trust versus out of the trust. We could do a hybrid DAPT with this floating spouse clause, but what we've done is we've added a sibling so that we had a real current beneficiary.
Yeah, I mean, I've done this where people say, I'm going to create a trust. I don't have any spouse, I don't have any descendants, but I want a trust. Well, to have a real trust, you have to have a current beneficiary. You can't just, you know, say, well, we'll add them later. So, you know, you can do that. You could put in a sibling, you could put in a cousin, you can make it purely discretionary. But that's something that you can do. You can set it up now, and it probably doesn't need to be a grantor trust, at least now. In fact, you know, you can, if you do get married at a later time, maybe your spouse comes in, and, you know, maybe you face the income tax issue at that time, but not before you get married, certainly. And in fact, you could say,
oh, I'm sorry.
Pardon?
No, I thought you were done. I'm sorry. I didn't mean to interrupt.
No, go ahead, Marty.
I was going to say, in a context like that, we've used a sibling. We've put in a power for somebody to be able to add a charitable beneficiary, or we've even permitted charitable beneficiaries, because what if you don't get married and don't have kids? You may want to direct more of it to charity. So lots of flexibility. But again, this is the key point of what we're trying to get across. Look at all the variations and options. And the kind of trust, it was a great question, but the kind of trust that's being created now by a very wealthy young person who's single with no kids that contemplates all that, look how different that is than the simple islet that is a SLAT. And that's kind of a SLAT for a future spouse, if there is one, versus the much more complex ones that we've talked about. So that to me is the heart of this. We can use the SLAT technique, and if you use document generation like ILS, look at all the options, and it's as easy as clicking a button, and look at what variations you can create for whatever the situation the client faces. I'm not disagreeing with any of the comments in the articles or the webinars, seminars, conferences that people have made about reciprocal trust or divorce or all these other issues. All I'm trying to suggest is there's so many options that we have at our use that we can offer clients options to address those risks. And if the client says, you know what, I heard your options, I'm not comfortable, then you do no planning or you go on to something else. Personally, I'd rather take some of the risks and incur some of the complexity to get the asset protection planning, if nothing else, than to not plan because of these risks.
Well, I agree, Marty.
So we have some practice considerations here. These are just good tips about communication and what to put in a retainer agreement, talking about the differences between trusts and having a financial planner, prepare some projections to show, how things are going to move forward, and maybe we can identify gaps that might be filled by life insurance or other types of insurance. So I think these are just good considerations for protecting yourself as the practitioner and communicating to clients.
Let me tell you a couple of things that we do. We recommend to every client that's doing any kind of significant irrevocable trust, and certainly if it's a couple doing SLATs, get your financial advisor, your insurance consultant, see what financial planning and insurance can be done, to fill the financial gaps that are inherent in every SLAT type or like plan. So if a spouse dies prematurely, the settler spouse, unless it's a SPAT or hybrid DAP, can't get access. You don't like the idea of a SPAT, well, then maybe you have life insurance in that SLAT that your spouse created to compensate you because you no longer have access. So you could use a SPAT or have your spouse buy life insurance. There's all these different options and trade-offs, which is why you don't reject them. There was a comment made at Heckerling that I thought was so profound. I just want to share it. It's on one of the slides that we just went through. I actually updated our retainer agreement at the lunch break that day. One of the speakers, and I can't remember who it was, said, provide in your retainer agreement that if you meet with one spouse and not both spouses, they both consent to that and agree that whoever met with you will inform the other spouse who wasn't present of the discussions. I thought that was a brilliant idea, because we will not sign documents if we don't have discussions with both spouses that are going to sign. I'm not going to sign a document because husband reviewed it and wife never saw it. You don't want to do that. But I thought it was a really clever idea to put that in to protect. The other thing that we've been doing for years, and I wish I'd thought of it even years sooner, is we use ILS, and ILS has, and we'll illustrate this in the next session, and even if you don't use ILS, the concepts will be very valuable. SLAT 1, SLAT 2. We extracted from the documents the differences that the SLAT options in ILS that we use create. We put them into a standard letter or memo, and that is sent to every client. So they cannot say that they didn't understand that there, and we say in the letter, these differences were included to endeavor to deflect a reciprocal trust challenge, but they have real substantive economic consequences. I don't want someone to come back and say, oh, I didn't realize that my spouse could pull out 5% of the trust every year and I couldn't. 5 and 5 power is really powerful, and over the years or decades can move a huge amount of wealth outside of the intended plan. And I did an article with somebody from, I think it's Bison Trust, on projecting what that 5 and 5 power, pulling out 5%, investing it and compounding it outside of the plan can do. It's monumental. So it's important to make sure clients understand, yeah, we're doing this for a tax reason or for creditor protection to break the reciprocal trust, but there's real economic consequences. If there weren't real economic consequences, they wouldn't work.
By the way, let me mention that just because, you put it in your letter, you say, you've agreed that we can meet with one of you at a time, and that spouse has an obligation, and by signing this letter agrees that he or she will inform you of what was said. Don't be that shocked if a spouse feels that he or she was kind of cheated in the representation, that even though you've got that in there, because I once had a client say, well, you sent me this very long letter. I can't read this. This is a bunch of legal gobbledygook. I just trusted that you were going to do the best thing for me. So one of the things that I have done where I really anticipated a problem is to actually have a meeting that is recorded. And I once had a situation where that happened, and sure enough, Things did not work out the way that the child wanted. The child later came back and said, I'm going to sue you. But I sent the lawyer who was allegedly representing her not only my letter, which went through all of this, but the 2-hour conference that we held. The lawyer called me 3 days later and said, I have told her I will not represent her. You did everything. So if you're anticipating a problem, try your best to protect yourself, because clients, they'll say, I don't understand this. I relied on the lawyer. I was thinking that the lawyer was doing what was in my best interest. I can't understand this legal gobbledygook. Marty is right. Try to protect yourself, but there's nothing that is absolutely foolproof.
Jonathan, what you just described was exactly an argument in one of the major malpractice cases a few years ago. And one of the things that we did in light of that case and what was said in that case, we always meet with both spouses before we'll let them sign something. But what we also now added post that case, exactly because of what you said, and it's bold and underlined in a letter, and in our engagement letter and everything else, do not sign any document that you haven't read and understood. And when we send out a draft, don't agree to finalize this if you don't understand it. After they sign the document, the cover letter that goes out with the original documents says that by having signed this, you have acknowledged that you read and understood it. If that's not the case, notify us immediately. The point that you made is it's unfortunate, because I think in most cases, most practitioners do make the effort to speak and help both spouses, but we do have to be careful of that. And that goes back to, it's not just about the risk of divorce or the risk of reciprocal trust doctrine. What Jonathan just brought up is another risk that's come up in actual malpractice cases where one spouse says, hey, I never really knew any of this, or both say that. So I think it's dangerous to be focused on one technique, and it's better to be focused on as many issues as we can. But again, what we're presenting with all these different flavors, if you're giving options to the client, and this is one of the themes that I learned from all the malpractice cases that I've read and written about, if the client is making the final choice, not you, because you gave them 3 options, client, which one do you want on spouse? Which one do you want on whether it's a SPAT, hybrid, DAPT, or SLAT? If the client makes those choices and you show that you gave options, it's much harder for the client to say they didn't understand. They made the choice. You can't tell me you didn't understand there was a risk of divorce. You picked the option. Teresa, you want to talk about all our flavors?
Well, I mean, we've been counting the flavors up because we've been touching on these things as we go along. And I think when we get to this point about, we've talked already about putting the trust in a jurisdiction that is friendly and has self-settled trust, domestic asset protection trusts, or having it where we can move it there later, or we could decant into a trust in that state. So we've talked about a lot of these things already, and I think at this point at Flavor 14, we stopped counting because there are just so many. Because what we have, I think, on the next slide and going forward are discussions about the income tax consequences and the step up in basis and those things, which I thought we might want to get to sooner rather than later, if that's okay.
Yeah, let's do it. These upcoming slides, I've heard comments made that below a certain amount of net worth, a SLAT may not make sense. I said earlier that a context in which I don't agree with that, if you have a young couple, a young client, doesn't have to be a couple, that is concerned about asset protection, why would you wait to set up a trust, especially in light of the holding in the recent Delaware case? So asset protection is something important for clients worth a couple $1 million. And forgive me, I know I'm sounding again like I'm selling ILS. It's not the intent. It works. You can use document generation software to cost effectively and quickly draft an incredibly sophisticated trust. Jonathan and I always disagree. He tells me you can draft a complex SLAT in 15 minutes. I say it takes at least an hour. But the difference is inconsequential in terms of cost. There's no reason with the tools that we have, and in the next session where we demonstrate drafting, we're going to show you how to use AI to both protect yourself and explain all these options to the client. And if you haven't used what we're doing, I think you may find it very interesting. But clients can benefit from a non-grantor trust. You don't need a lot of wealth to be able to salvage a charitable contribution deduction. And Jonathan, please don't talk about the 237s. But you don't need a lot of wealth to salvage tax benefits post-OBA. So creating a non-grantor trust cost effectively in ILS, and again, Jonathan and I disagree. He thinks you can do it in 15 minutes. I'll say it takes at least an hour, and then you need some follow-up. But for a modest amount of time, you can create a grantor or non-grantor trust. You can create an irrevocable trust for asset protection planning, grantor or non-grantor. And that, to me, is very powerful. The same techniques of a SLAT can be the foundation for a plan for a client worth $1 billion. Why would you ever use a SLAT for a client worth $1 billion? Jonathan and I were working on a client that I believe is worth about $800 million. We don't quite know what the value of these hard to value assets are. And one of the biggest challenges post-SLAT, we created non-reciprocal. I believe they're non-reciprocal SLATs for husband and wife, one in Alaska, one in Nevada, different assets, different things. One of the biggest challenges is after the very large note sales, the notes were paid off far quicker than we thought, not because of any reason other. The motivating factor was the clients needed the money because their lifestyle expenses were so high. So the biggest challenge post note repayment, and we always dream of getting the notes repaid because then what else is there to pull it back in the estate, right? You're home free. Well, we thought we were home free. The celebration didn't last long because then the client said, well, how do I get money out of this trust? So we found other assets to sell to the trust to create new notes to keep the cash flow going. So depending, I understand the concept. It's safer to create a mere dynastic trust and not include a spouse from an estate exclusion perspective. But even clients with incredibly large wealth may need access because they also may have even more incredibly large lifestyle expenses, right? Those boats and 5 massive homes all over the world all create a lot of cost to pay for. So SLATs do provide a means to address that. Jonathan?
Oh, I agree with you, Marty, except I'm not sure I always said 15 minutes. Sometimes it takes a lot longer than that. But the point is that you want to give yourself and your clients the maximum flexibility.
Yes.
And record what decisions were made. It's really very important for you to do that. I mean, remember the reason that the SLAT came about is that people said, well, gee, I've got this big exemption and I really should be using a significant portion of it because the law may change. And let me say right here and now, the law will change. It never is stagnant, and it's gone down. The exemption has gone down in the past, and maybe it'll go down in the future. But you want to be sure that you have got enough flexibility that as situations change, you can change. I mean, I've known people who are very, very wealthy who had an economic misfortune, and they really had to rely on this stuff. So you need to be very, very careful about what you recommend to people, because they may come back and say, you didn't warn me that I could lose all this. Yes, you can. Keep in mind that the United States is the most litigious country in the world. I think 1 in every 7 people get sued at least once a decade. So it doesn't mean that, you're a surgeon, Marty mentioned, or that you're a trust and estates lawyer where the potential for liability is great. But it also could be that, I'm worried about Marty because Marty lives next door to a home which has the only talking cat in North America. And I've noticed that when Marty backs out, he's not so careful. And if he hits that cat, he's going to really get a bad lawsuit. Now, obviously, I'm making this up, but it can happen to really good people. So make sure you take into account that the primary reason for a trust is asset protection. And when you have to start with that. And that's why I've spent my entire career telling people, don't have the trust end at a certain point in time. Keep it going for as long as you possibly can. Because, you know, bad things happen to good people, like happened to Job in the Bible. So don't let your client be a Job.
Let me repeat and emphasize what Jonathan said, because Jonathan just made the case why SLAT-like, and when I say SLAT-like, it means SLAT, SPAT, DAPT, hybrid DAPT, tax reimbursement, loan provisions, all the different variations that we have, that we've talked about, many, not all yet. But Jonathan just made the case why SLAT-like trust planning is so important. I talked about lifestyle expenses being significant, so even uber wealthy people may need access to the trust. But Jonathan just raised a point that we, without a crystal ball, unless you have a crystal ball, we can't tell if a client could have a major financial reversal. Look what just happened to the value of Bitcoin over the last number of months, right? So clients can have significant financial reversals. Businesses fail. Clients get sued. We need to give access because of that risk, unless the client chooses not to, but we can offer it in all the variations that we've talked about. But because of the risk of financial reversal or different financial needs down the road, because of the risk of potential changes in the estate tax, those factors are why trusts where you can get access to them and asset protection and estate tax savings, even if you don't really need it now, seem to me to be vital to what we offer clients and do for clients. And that's the whole point of this presentation, is there's so many options. You can tailor that to the needs of the client, but don't forget the warnings Jonathan said. Whatever the tax law is now, it's going to change. I won't want to guess where and how and when, but it's going to change. Clients could quadruple their wealth or have their wealth cut by, a factor 10. All possibilities are out there. Flexibility using all the different variations is what helps protect the clients. And dismissing a technique like SLATs because of any of the issues that it faces, and I'm not minimizing those issues, may be a mistake for the client, but let the client make that decision.
So
Teresa,
we have some questions. Yeah, so we have some questions about assets, type of assets you might put in, and there was a question about estate inclusion for a non-moneyed spouse. And with assets, there was a follow-up question of, does it matter about built-in capital gains? So I think all those issues get down to these few slides that we have here about what to draft and not to draft. And we're not saying, here's what you must draft. The point here is, if I'm drafting for these particular clients, what do I need to draft for them? And what do I not want to draft for them? So I want to draft for them, maybe because of their situation, a grantor trust. I want to avoid the non-grantor trust. I want a completed gift because I want estate exclusion. Or maybe I don't. So it's every factor is, what do I need to draft into this trust that relates to this issue for this particular set of people? And so there's all kinds of different assets you could put into these trusts. And again, when you said SLAT-like, Marty, I wanted to just again say, all we're talking about is any irrevocable trust where the spouse is a beneficiary. But then
or
you
could
have
become
all
a
the different
beneficiary,
ways you can set it up, or could become a beneficiary.
or
Exactly.
could receive assets even without being a beneficiary, like the SPAT.
Mm-hmm.
That's why to me, again, and I'm sorry to keep harping on it, but I think it's so important because I've heard so many comments and seen so many articles and presentations that take a different perspective. There's so many options. You don't dismiss SLAT-like planning, and similarly, you don't confine yourself to only a very narrow list of SLAT techniques or mechanisms, because there's so many. I want to see, I don't mean to put you on the spot, Jonathan, but I'm going to. And obviously, we're not going to mention any client details. I met Jonathan over a SLAT-like plan where there was an unusual asset going into the trust. Do you remember what the asset was, Jonathan?
I don't, Marty.
Paintings, art.
Oh, yes.
Yeah. So, and by the way, the uniqueness of the assets also changes up the plan. If you're going to have art, you not only may want an investment a trustee or investment advisor for marketables, you may want a separate investment advisor for art. And in fact, that was the core of what Jonathan and I were talking about when we met many years ago.
I mean, you've got to think about it, but maybe it depends on why you're creating a SLAT. I mean, if it's to make sure that your spouse has enough assets that regardless of who dies first, you're going to be able to use the exemption. You can use that for art as well as for things that might appreciate or generate a lot of income. And if it does, you can have, a grantor trust issue. But keep in mind, even if you're funding the trust with art, if that art is sold, it will be the grantor who's going to pay the income tax on that, even though you may not want that result. So yes, the kind of asset you fund the trust with is an important factor in considering the terms of the trust. But keep in mind that no matter what you have in the trust, it can be sold or traded, and you wind up with an entirely different basket of assets. And keep in mind that the taxation of that asset may change because of a change in federal law. I mean, at one time, go ahead, Marty.
No, finish. I'm sorry. I thought you were done.
I was going to say, at one time, we for a long time have had special treatment for asset that would produce long-term capital gain. But there have been proposals that would change that result, that all gain would be taxed as ordinary income. And some have suggested even higher. And keep in mind that you may have a wealth tax at some time. Now, there are questions about the constitutionality of that, but let's assume that, it could get through the Supreme Court, and now you're going to have tax on a regular basis, even though, didn't fund it with income producing assets.
So keep in mind, when we talk about the risks or limitations or issues or access to a SLAT-like trust, on the bottom of slide 23, loan provisions, tax reimbursements, adding charitable beneficiaries, even if it's not a hybrid DAPT or SPAT, those provisions can provide pretty substantial benefit. Jonathan, if I'm worried about the risk of divorce and I'm creating a SLAT for my wife, if I have in that trust somebody in a non-fiduciary capacity, you, that can make loans to me, and if I have a discretionary tax reimbursement clause and I have an independent trustee, wouldn't that give me a lot of assurance that that grantor trust problem post-divorce could be mitigated through loans to me and also to tax reimbursement, through tax reimbursement?
Well, Marty, it will help, no doubt, in some circumstances, but it may not be the cure. First of all, what interest rate are you going to charge? And a lot of people say, well, we're going to charge the AFR.
No.
Well, the AFR only applies to certain types of loans under Section 1274 of the Internal Revenue Code. It doesn't apply to all of them. And you may also find that a beneficiary may object. Why are you loaning money to my now ex-husband? What gives you the right to loan to him? Yes, I realize the trust does it, but you're a fiduciary for me, the beneficiary. And loaning stuff to, my now ex-husband who hates me and is trying to ruin my life, you may have real problems, and that you don't want for yourself or for your firm. Again, those are good provisions to add because they add tremendous flexibility, but don't think there still can't be problems.
Let me make a broader statement out of what you just said. Some of the concern of divorce and the grantor trust status because of the change in the tax law after the 2017 Tax Act, I think, can be mitigated with the tax reimbursement clause. And I agree with Jonathan. It doesn't solve the whole problem because you don't want to have every single year, every single payment perhaps. But the point is that you can bring to the client lots of different options. You can do a SPAT, you can do a hybrid DAP, so now you're a beneficiary. We can do a tax reimbursement, or we can just remove your spouse. Which option makes sense is going to depend to a great degree on the circumstances of the particular client. What's their spending level? How much wealth is in the trust, out of the trust? What are their needs? And how do they assess these risks? But if we offer these options, and there's so many, there's thousands of options. When you add up all the different options, you could generate different types of trusts using any document generation software. We really can do a robust job letting the client choose what they want. And next session, we're going to show you how you can cost effectively and I think very efficiently and effectively communicate all this to the client.
We have some things here about fiduciaries because that comes up a lot. You know, you already talked about independent trustees versus the spouse's trustee, but then there's also the idea of splitting up the trustee functions, bifurcating them, naming trustees who have specific roles. Like here, the example is we have a distributions trustee and we're going to have an investment trustee and then a general trustee who's going to do, you know, the tax returns, but the other two have responsibilities exclusively for distributions and investment. And a related topic is a directed trust where you have a trustee, but then you have a distributions director or investment director. So I didn't know if you wanted to talk about that briefly.
Well, that's a big issue. I mean, one of the things is that I think one of the states, it may be Tennessee, I'm not sure, where it allows you even to waive the duty of good faith. Now, if you get to a point where you have a document and you say it's a trust, you can say whatever you want it to be. But if you don't have true fiduciary duties there for someone, you may not have a trust at all. And if you don't have a trust at all, I wonder what you do have. So, you know, as you kind of race for the bottom line, I want to waive everything, all the liability. I'm very concerned about that. I'm even concerned that if you have a directed trust and no one is liable because the director is not a fiduciary, you say that person or that institution won't be liable for mistakes that are made. And that person, you know, doesn't put someone else on the line if they make a mistake. I really worry, do you have a trust? And don't be shocked if a court someday says, you know, yes, I realize this said it was a trust, but we don't really find it to be a trust. Keep in mind, I'll give you just an analogy. You can call something a trust, but there are a lot of cases out there would say it's not a trust, it's a company, it's a corporation. Yep. And the line between where you have a true trust and where you have something that's going to be taxed as an association, in other words, a corporation, is not very different. You've got to load it up with fiduciary duty on someone, and trying to waive it all is to me truly problematic.
Can we go back for a minute to the slide on fiduciaries? And I want to give you the continuum and sort of make a point again, reiterating our theme. So if I had the old style simple ILIT, I set up an insurance trust. It has insurance on my life. My wife is the beneficiary. My wife is the trustee with a HEM standard. I got a really simple SLAT. The fiduciary is my wife. I don't have any of the complications or details here. The trust works. But that's the simplest version on this far end of the simplicity spectrum of what a SLAT can do. On the very complex part of the spectrum, I did an estate plan a couple of years ago, and there was a religious basis for it all that I'm not going to get into. But it really addressed the issues of a purpose trust. It addressed the issues of succession planning. We had the trust in a trust-friendly jurisdiction. We had a corporation formed, a special purpose entity formed under state law that served as the investment advisor. And that wasn't one person serving, but a board. We integrated into the operating agreement all the sort of analogous powers that a board of directors would have. So it wasn't one manager, it was a board of managers in this LLC that was the investment trustee for that trust. And it was a really complex, for very specific reasons that client had. And then we had a separate distribution LLC that was the trustee for distributions. and the client was excluded from that because of the tax sensitivity of the power. So we had an institutional trustee, we had an entity for other key functions that Teresa just checked a box off, and you could just name an ILS the entity, and then all the other documents are created separately. And I think it works much better.
Keep in mind the following. You can say that this LLC or this corporation is going to be the trustee, but keep in mind that in many, if not most jurisdictions, you just can't choose anybody to be the trustee. You know, every state you can have a human being be the trustee, but you just can't say it'll be, you know, a Stiftung that I formed in Switzerland or something. That may not be treated as a trustee. And again, you might wind up with a situation where you just don't know what you've got. And if that's the case, your creditors and the Internal Revenue Service will just love the situation because you haven't made it clear. So make sure if you're going to use special purpose entities to carry out fiduciary duties, that's going to be respected under local law, or you need to put in alternatives. So if my LLC can't be the trustee for purposes of directing investments, then it'll be, you know, the Chase Manhattan Bank or Peak Trust or something else. Make sure you have that in there to cover all your bases.
And what we did is got an opinion of local counsel. But the point I'm trying to make, from the simple ILIT to this complex structure, look at the incredible variation. Flip to if you could, Teresa, to the trustee things, and we'll try to move on from there. But again, there's so many different options on how to structure trust to meet whatever the goals or needs are of the client. You have tremendous variability. If you're using a pre-constructed form that you have, let's say in Microsoft Word in your office, you can't, I don't know how you could get this variability. But simply with document generation, you click, 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 all the issues, whether it be divorce or access or state inclusion or exclusion, whether it's complete a gift, not, you can do all of that in a very cost-effective way. And again, when you look at the concept of a SLAT, look at the breadth and depth of different options that there are. And all of that's before we even talk about the different assets that go in. If you have artwork in a trust, it's going to be very different than if you have marketable securities, and it's going to be very different if you have a family business. Okay, Teresa, tell us about the flavor tracker. I love it.
Well, this was just, you know, we counted flavors for a while and then we stopped counting. And so we know it's far more than 31. And I will say that apart from the taxes that we have to think about, you know, some of us might have said, well, there wasn't supposed to be any math. If you look at the other handout, Marty did math.
I didn't, AI did it. And I have no idea if it's
Marty
right or
used
wrong.
AI to do math and to show, you know, his first pass, he came up with over 4,000 variables. And then he added in another set of 4 options. And so we ended up with 60-some thousand variables. So I don't know how accurate it is, but, you know, there's so many combinations. Yeah,
that's the key. It's not different variables. There may be 50 different variables, but when you look at them factorial, it's a tremendous number. And the number gets silly. The point we were trying to make is there's so much options, so many variations, so many different provisions that you can use that you need to be careful dismissing a technique unless you look at all the options of what it can do. And I think Teresa said it very early on in the presentation that the document generation software is almost like a checklist to think about all these things as you go through, and it is. So look at what you can create with it. The last few slides she went through real quickly, I can say in 1 minute because I don't want to belabor it. I agree with everything I've heard and read about all the issues and risks of divorce, and that there's lots of options to deal with it. I believe it's the client's decision to make that choice. But I think there's another issue, and I've never heard anyone talk about it, and it kind of dawned on me. It came to me when I was reading some of the materials talking about the risks of divorce. One of the risks that's significant, which is actually different than the divorce risk, is what I'll call the bad spouse or the over-controlling spouse. And we kind of talked about it a little earlier. Jonathan made a few comments. If you take a look at the Grace case, The husband in the Grace case made all the decisions, had people, he dictated what went into the trust. He decided what the assets were. He controlled the business that went in. It was almost as if he went to his wife and said, sign here, sign here, sign here. She had no idea what was going on, left all the decisions to him, had no involvement. That's a problem. In the Smaldino case, the husband orchestrated the entire plan using the wife as a straw person to simply as a, to get assets, trying to use her exemption into a trust for his kids from a prior marriage. She had no involvement. She simply wanted to adhere to whatever he wanted because it was his money. Well, he overly controlled everything. There's a divorce case that Carla McCaffrey spoke about at Heckerling, which was really interesting, and it's worth reading, because in that case too, the husband so controlled everything that went on. The wife was saying, hey, I didn't know what any of this was. I signed what I was told to. That is a red flag that we all need to be mindful of, whether it's from creditor protection, estate inclusion, divorce risk. Is one spouse overly controlling or totally controlling the entire process? And Jonathan talked about it a little while ago. That to me is a significant issue that I've never heard anyone really identify, but that is part of what the real issue is that we have to be mindful of.
Well, so I think our conclusions are pretty obvious. We will spend the last few minutes, I think, answering some final questions, but let me also add here a quick comment about upcoming events. The follow-up webinar that Marty was mentioning, I've called it Drafting All Flavors of SLATs, but it will be a drafting kind of workshop going through these issues. It will be in March. You'll get invitation emails for that. We'll figure out the date for that. We have an upcoming webinar too.
Let me just real quick, whether or not you use ILS or you don't use any drafting software, I think you're going to find it very instructive. And not only are we going to show you how we draft two very different kinds of SLATs, we're going to show you how to use AI to generate a really inexpensive, really robust memo to protect yourselves as practitioners and to explain all that you're doing to the client. And I hope you find it interesting. It's going to be very different.
Also, the fourth item on this list of upcoming things just happens to be what Jonathan mentioned earlier. Well, he mentioned keeping assets in trust, but we will have a master class on why putting everything in trust is the answer with Jonathan and some co-presenters. We don't know when that's going to happen, but you can watch for that too. And the Interactive Legal Academy has a 4-week course that happens in April and October, depending on if you have folks in your office who need to learn basic estate planning or estate planning tax issues. And in 2 weeks, we're going to talk about tax issues for people who draft trusts. And then also, finally, I should mention our AI. We're going to do a 2-part series on AI. All this is stuff that's coming up. Let me take a look at some other questions. There was a good one about, back to the reciprocal trust doctrine. One of the things that we talk about is making the trust different and also creating them at different times. And this was kind of a good practical question. How do you approach your married clients who you're working with and say, okay, we're going to create this trust now, husband creating it for wife, but we'll come back next year to do the other one. I mean, that seems like, they're going to want to know why, and I guess you explain why, but practically, how do you address that?
Well, one of the things that I did when I wanted my wife and me to make some gifts, because we thought that the exemption was going to be decreased, I created a trust for Betsy, and I didn't even tell her. And then I had the attorney go to Betsy more than a year later and say, Jonathan created a trust for you. And she said, yeah, I understand that. Well, do you think maybe you should create a trust for him? And I felt that that was one of the most important factors, because, it wasn't in response to what the other spouse had done, because Betsy didn't even know I created it for her. And there was no suggestion that she would create a trust for me. So if you can do that with a couple, that's really good, but you do take a risk that the other spouse will not be cooperative.
Let me make a couple of comments on that. I may be wrong, forgive me, but my recollection is only one case, and I may be wrong, talked about the time frame between trusts, and in that one case, there was 18 months between the trusts. The concepts, as I read it, and I may read it differently than Jonathan or all of you, in the estate of grace was, are the parties in a different economic position after the plan than before the plan? If I create a SPAT for you and you create a hybrid DAPT or SLAT for me, if I have a 5 and 5 power and you don't, if I have a HEMS limitation on distributions to me and you have a discretionary distribution standard, I'm not sure we're in the same economic position. If my wife's trust that she created for me buys a $5 million insurance policy on her life, and the trust that I create for her doesn't buy any insurance on my life, are we in the same economic position? I think time is certainly an important factor. If I had the luxury, I'd have them in different tax years. I'd have a year between them if I had the luxury. Is that really necessary? I don't think that's what the fundamental test is. It's different economic position. Now, you could explain to the client, listen, the more different these trusts are, the better. One of the ways many advisors have talked about differences is time. Are you comfortable with one of you doing this and the other not? I have a case I'm working on now where one spouse set up a trust for the other one, and then a divorce was filed. A divorce, they filed, the spouse that was the beneficiary filed for divorce 6 months later before the other trust could get set up. So, you know, again, I think you have to be very careful using a standard answer. You really have to give the client options and see. But my reading of the reciprocal trust doctrine cases is the focal point is economic differences.
There is a case
let's
called Estate of Bischoff. You may have seen the Boarhead brand on the back of trucks where they have a picture of a wild boar. And that was the Bischoff family. And it was a great family. They were headquartered in New York. But in that case, although some people feel it doesn't apply, they applied the reciprocal trust doctrine not because each of them had the same economic interest, but because they both wound up with powers of appointment, special powers of appointment. And the court said that that was enough to trigger the reciprocal trust doctrine.
I like this one. Do you really expect clients to read the entire document, or are you just trying to give them the opportunity to read and ask questions? And my first thought was, well, I think I expect them to read the memo that you talked about, Marty.
The clients should be responsible to read everything we send them. If they choose not to, there's nothing we can do. To protect ourselves, we should ask the clients, have you read and do you understand? Before somebody signs a will or a trust, certainly a will is part of the will signing ceremony. Have you read, is this your will? Yes. Have you read it? Yes. Do you understand it? Yes. If they say no, you're not going to supervise the finishing of that signing of the will. Clients have to be responsible. A client is not going to sign a contract or shouldn't sign a contract to sell an expensive home or an expensive business or an expensive investment property without looking at it. They need to understand it. But that's why I think repetition is important. That's why we put clauses in our engagement letter. That's why we send a cover letter and a memo after each meeting, almost every meeting, certainly after the first primary meeting. We send a summary with key points when we send out a document. And we're going to show you how we do some of that using AI to make it more cost effective, which is something that we've only just started to do while drafting an ILS. But I think that's really their responsibility. If a client tells me they didn't read it and they don't understand it, I'm not letting them sign it. I actually have this issue right now with a client. And it's actually very interesting. In the last web meeting, I had it transcribed. I went through it. They must have said a dozen times that they're not clear, they're not sure, they don't understand, they're thinking about it, they may want to change their mind. I said, I can't finish this document unless and until you address all these issues. I have to know you know what you're doing.
Well, we know in the real world, people don't read the entire trust or the entire will. They just don't. And we also know that even if they've read it, they won't understand it. I mean, it's hard enough for us to understand all the stuff we have in there. But the law presumes that they've read it and they understand it. But don't be shocked if someone comes back, especially if you're the drafter, and a problem arises that, gee, I didn't understand. I had a client who had a master's in business administration, and he was upset about something. And he said, well, you don't really expect me to understand this stuff, do you? I mean, what can I say? I mean, it could even happen when you have a lawyer from another field or even in another field. No, you know, my partner created this, I signed it, but I didn't know what I was signing.
Teresa, have you ever taken Advil?
Yes, but I don't know how that relates to what we're
I'm going to
talking
tell you
about.
exactly how it relates. When you buy a bottle of Advil or Tylenol, there's this little wadded glued piece of paper inside that if you actually take it apart, it's a whole series of disclaimers and caveats and warnings and cautions and criteria for how you take it. I mean, it's the same kind of thing. Does anyone actually read it? Why is it there? It's there because it's now on us as the consumer. We were warned. We shouldn't be able to say we didn't know. Clients have to have the responsibility to put the attention and time on this stuff. But that's why I also think repeated communications and cautions to clients in different ways help. That's why I think it's wonderful to collaborate as a team. Because if the financial advisor is talking about insurance coverage or asset location decisions on the investment assets in the trust, and corporate counsel is talking about the transfer of business interests, and the accountant's talking about the income tax implications, the client has now heard from 3 or 4 different advisors. They can't say they didn't understand this. They've heard from all these different people. And that's also why I think the idea of giving a client options is so critical. If Jonathan, if I offer you 3 different options, a SPAT, a hybrid DAPT, or a traditional SLAT, and you make the final decision, and that's what my documents reflect, doesn't it seem to imply that you've had to have some understanding, because I'm relying on your decision to proceed?
Of course it does, Marty. But you know what, the client often will come back and say, well, what do you think I ought to do? What would you do if you were in my situation? And that often happens. And, you know, it's like if I go to a surgeon or I go to a doctor and he said, well, you have gout. And I say, well, what do I do? Well, there are 3 things you could do. And my response, and I'm going to tell you, is always, what do you recommend for me to do?
I asked the question differently. What would you do if you were me? Same question.
Yep.
But I think we have to be careful. That's a really important question for protecting us as practitioners.
Yeah. I have a veterinarian who will say, here's what I'm supposed to tell you. And then he will tell me his recommendations. So.
Be careful.
Okay, so I think we've kind of gotten through all the questions. We've gone over about 7 minutes. So I think that we're good, and we can follow up on any other questions that I missed via email. Are you guys good with that?
We may be able to cover them by integrating them into the second follow-up webinar. And I really hope you all join us. It's kind of an experiment. I think it should be interesting. And for the second webinar in particular, I'd love to hear any feedback, especially criticisms that anyone has, because I'm going to propose something that I haven't really seen done a lot. And I think it could be really a material change in how we draft and interact with clients, and will address the very concerns Jonathan was raising, I hope.
I hope so too. Well, we look forward to seeing everyone then. And thank you, Jonathan. Thank you, Marty. This was fun. We'll see you next time.
Thank you, Teresa.
What could be more fun than SLATs?
Yeah.
I'm not sure. Bye.
Thank you.